My first guest is Mahesh Jaitmalani, Senior Advocate, Supreme Court, someone who was closely associated with the BJP and has been a nominated MP in Parliament as well. Appreciate you joining us, Mr. Jaitmalani. Where do you stand on the question that is now increasingly being raised that members of the BJP in some form or the other are making a concerted attempt to intimidate the judiciary as seen by the statements of their senior MP Nishikant Dubey, and that the government is even using constitutional authorities like Vice President Jagdeep Dhankar as part of this attempt to intimidate the higher judiciary when it is dealing with several important cases, and therefore this amounts to contempt of the judiciary?
Rajiv, first of all, I think anybody who attempts to intimidate the judiciary is indulging in a completely misconceived exercise doomed for failure, because I don't think that the judiciary gets intimidated. I mean, there was a time perhaps when, things were much more autocratic in this country, and I'm talking particularly about the emergency period when judges were, there was those 2 years where, yes, judges were really intimidated. There was a fear psychosis created in the country. But I don't think either before that, I've been in practice now for well nigh 42 years. Even then, before that, I used to accompany my father in many of his celebrated constitutional cases where he was fighting for freedom. And I never thought the judiciary was ever intimidated except for that brief period. So I think this is a misconceived notion, right? If anybody's tried to intimidate the judiciary, is not likely to succeed.
No, Mr. Jethmalani, the fact is that a BJP MP like Nishikant Dubey stirs a controversy, alleges that the Chief Justice of India, Sanjeev Khanna, is responsible for all civil wars in the country, then goes a step further, accuses the Supreme Court of inciting religious wars. Surely that when that is done, and when you have a BJP MP and a former Deputy Chief Minister of UP, Dinesh Sharma, also joining in, the BJP social media army joining in to criticize the Supreme Court, I mean, is this not an attempt in some way to put pressure on the Supreme Court to draw some kind of a line?
No, but why say intimidation? I mean, why do you attribute a motive to intimidate? Maybe a motive out of frustration. They may not be happy with, for instance, that Waqf board case, etc. And I'm not suggesting they were justified if that was indeed their motive, as opposed to intimidation, that it was a venting of frustration because of a temporary status quo order, etc.
Mr. Jethmalani, you are saying venting frustration? But that is a very dangerous thing if a member of parliament starts venting frustration in a manner, making these kind of absurd claims against the Chief Justice and Supreme Court. I mean, this would eventually head to a very serious constitutional crisis if all of this is allowed to continue in the public domain, surely, sir.
Well, I disagree with you. I think if the motive was intimidation, it would be worse. But if it's venting of frustration, that's okay. They're venting frustration. I mean, they're disappointed, and it doesn't behove. It doesn't behove, certainly, lawyers, for instance, to vent their frustration in that manner. But a layman might do that. It happens so often. A member of parliament should also not do it. And therefore, since he was a member of parliament, the party president has distanced himself from it and said his views are not our views. It's his personal view.
No, you're saying party president has distanced himself from Dubey's remarks, but somewhere isn't this part, I come back to it, of a concerted effort, you don't like the word intimidate, but to then bulldoze the judiciary. I'm not using the word intimidate, bulldoze the judiciary into falling in line on contentious cases like the Waqf board case, for example.
Rajiv, you are trying semantic jugglery with a lawyer. You are now replacing the word intimidation with bulldozing, which, to my mind, is roughly a synonym. So, okay, I still don't see that this is actually an attempt to bulldoze, because I don't believe that anybody, any reasonable man with a modicum of intelligence in this country, would believe that the judiciary, which has a lot of support in this country, and also which is a very powerful brethren in itself, right, can be intimidated.
But you agree, Mr. Jethmalani, that the kind of statements that a Nishikant Dubey has made are avoidable and hence surely should be censured? You agree with that or not?
Yes, 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 yes. That these
Okay.
and that Mr. Nadda's, the president's censure was justified. Yes.
But some would say Mr. Nadda needed to do much more. You need to do maybe a show cause notice. You need to do much more than just simply say that, these are his private remarks.
Well, this is much more than a censure. It's a clear enunciation that this is not the party's view. What more can you do?
Mr. Jethmalani, the problem is all of this is coming against the backdrop of Vice President Dhankar also then going ahead and saying that the judiciary, the Supreme Court is acting as a super parliament, saying that the Supreme Court is using the powers it has under Article 142 almost like a nuclear missile against democratic process. Is the Vice President here also not overstepping his position in the manner in which he is going ahead and targeting the judiciary?
Well, I mean, you can disagree with his choice of words, and I do. I do disagree that 142 was being used as a nuclear missile. I mean, that may be a little too strong, a little too intemperate. But, I think what he was probably taking up cudgels for was the case in hand, mainly where, the court, a two-judge bench, had passed a judgment regarding, circumscribing and keeping a time limit in particular on disposal of bills by assent to bills by the governor and particularly the president. This is the vice president speaking, right? So he could be zealous about his jurisdiction, or at least, his jurisdiction in times where he may be the acting president. And certainly speaking for the president herself in this case, that maybe a time limit imposed, and that too by a two-judge bench when it ought to have been done by a five-judge bench, was not in the interest of propriety. That's one. And secondly, also I think that it may be a little bit of a little bit of pique that it was done in a matter in which one really did not need to go into the president's powers at all, because that case was finally disposed of by saying that the actions of the governor were wrong, and that therefore his decisions in respect of all 10 bills were wrong, and therefore the question of him forwarding bills for the consideration of the president after it had been a second time reaffirmed by the assembly was totally misconceived.
But Mr. Jethmalani, the fact is in all the cases where we are seeing the whiff of a judiciary-executive confrontation, for example, the case you cited, the governor of Tamil Nadu is not fulfilling his constitutional duties by not giving assent to bills passed by the legislature. In such cases, where governors are seen to virtually act as agents of the center against opposition-ruled states, do you agree that the Supreme Court is duty-bound to remind the governors of not acting in bad faith? If the judiciary doesn't act, then who will?
No, I agree. But perhaps, given this is an alternative view. I'm again not saying that the decision was unjustified or whatever, except for the fact that it should have been left to a larger bench, right? But I'm not saying it was totally unjustified. The judgment actually reads quite well, and you are right that it is necessary for bills to be passed expeditiously. I'm not differing even on that point of view. But perhaps if they had at the first instance, right, given the fact that there are clearly that the lawmaking function, right, belongs to the legislature, right, and the judges only apply the law. And they don't create it, right? Now, when you put a time limit, which is not put there in the Constitution, you are reading something which is not in the express words of the Constitution. It may make for an interpretation that makes the entire passing of bills procedure more efficacious, right? I concede that, but essentially the function belongs to the legislature, and perhaps they could have in the first instance, right, said that the legislature should take cognizance of this and pass appropriate time limits if the legislature wants, right, whether it's 3 months or 6 months. But for them for the judiciary to put a specific period, and there may be other considerations which may suggest that period is not appropriate. It is best left to the legislature to decide it.
But let me then ask you in conclusion, are you not worried as someone who's been, as you said, in the profession for decades now, that increasingly members of parliament, MLAs, and even worse, constitutional functionaries like the Vice President believe it is open season to target the judiciary, because the sense is the judiciary is the one body that can control some form of executive overreach at the moment. And the executive doesn't want that to happen, and therefore they are targeting the judiciary in this manner.
No, I just think that for a long time, the present government, for instance, has conceded a lot of space. It has, from the Loya case, which was an exercise in total misconceived PIL, which the judiciary itself said, till to the Rafael case, to the Adani case, all of which have been rejected, right, by the Supreme Court itself. I think the government has shown extreme tolerance, and they have to contest in all these cases, right?
Sir,
and all of them have been dismissed and found to be without any reason.
So it seems, Mr. Jethmalani, the government shows extreme tolerance when the judiciary supports a decision taken by the Modi government. And when the decision goes against the government, then there is an open season and the judiciary is criticized. It is accused even of inciting a civil war. Isn't this a classic example of intolerance being shown by the government?
But perhaps Rajdeep, you are extrapolating a little bit too much, because this is one MP, right? One MP who has made a couple of statements. That is Nishikant Dubey, right? And it has been made very clear that the party doesn't support it, and certainly the government doesn't. He doesn't represent the government. He's not a member of the government. He's a member of the legislature.
Okay,
right?
But does the BJP, in your view, support the idea of a fully independent judiciary or not? Is the BJP in support of the idea of an independent judiciary?
I'm now going by example. Yes, it does, because the BJP has, by its conduct, repeatedly respected the decisions of the judiciary. It is members of the opposition who castigate the judiciary when they lose cases which they think they ought to win. I'll give you many examples. It is the opposition, right? Mm-hmm. Which constantly, when they lose battles in court, carp and undermine the judiciary.
Okay, I'm going to leave it there, Mahesh Jaitmalani. You're feisty as ever. You've given us what you believe is your response to this judiciary versus executive face-off. Appreciate you joining me.